This is Jennifer Sigafoos from the Charity Law and Policy Unit at the University of Liverpool School of Law and Social Justice, and I'm just going to give you a brief summary of a paper that Dr. Karen Atkinson and I are giving in London at our London Annex. The paper is entitled Transatlantic Controversies in Charitable Lobbying, and we're going to briefly sum up the regulation of charitable political speech in England and Wales and the United States. We're going to draw some comparisons and contrasts between the varying regulatory regimes. We are going to discuss some controversies that have arisen for charities even when they have engaged in what should be perfectly permissible and allowable political speech, and some of the potential risks that poses for charities, and how potentially the risks for charities from political speech are much bigger than those that arise simply from the potential for a regulatory intervention. And then we're going to discuss whether or not these restrictions are in fact desirable, and whether we should be encouraging and enabling charitable political speech to a much greater extent. And we are going to argue that charities should be allowed to campaign, and that in fact the restrictions on charitable campaigning should be only the sorts of restrictions that are that take place around other charitable activities, that trustees should be able to decide on behalf of their charity that the charity should engage in particular political campaigning, and they should be only limited by whether or not they're able to advance their charities charitable objects by these activities, that there shouldn't be other restrictions on the amounts of the activities that should be engaged in. And we'll also consider another point about whether or not charities should be allowed to engage in party political activities, though I think that is a much more in development idea for the paper. Thank you.